Apologies for that. Good evening and welcome to session 4, the main risks facing legal practitioners. I'll once again take you through the presentation, and in this session we are going to focus on the main risks facing legal practitioners. I'll just mute my video as I bring up my presentation. A few preliminary comments that while we just bring up my presentation. It's not possible to look at every risk facing legal practitioners in detail, and that's just focused on the main risks. And you note that the main risks are also in line with the claim numbers that we looked at in session 1. So please consider these risks for your practice and how your practice is affected by them, and what risk management measures you have in place to deal with each one of them. And also look at them from the perspective of the insurance products you need to have in place. Word of caution: when you go to the market to look for the insurance cover, please instruct a broker who has experience in dealing with legal practitioners. Not every broker understands the risk environment of legal practitioners, or what the specialist insurance products that are designed for legal practices. So ask your broker what experience they have in dealing with the legal profession. And for current purposes, it's also prudent to look at to consider these risks when you deal with the assignments. So please remember what we cover in this session when we get to session 7, where we do an overview of the assignment questions, and then also when you answer the assignment questions. The risks that we'll focus on are the current operating environment. That's because law firms do not operate in a vacuum and are affected by what's happening in the broader environment. Cybercrime, prescription, undersettlements, theft of funds. And when we deal with each of those risks, we'll also talk about the regulatory and compliance matters that you need to consider. The coronavirus pandemic is without doubt the seminal event that has had an impact on our lives, both personal and professional, in the last 2 years. The legal practice, as I keep saying, does not operate in a vacuum and is affected by the pandemic. There have been losses of lives, there have been illness of legal practitioners, and certainly it has affected the very existence of many legal practitioners. The lockdown measures that were implemented as part of the national state of disaster, particularly the period of the hard lockdown, restricted human activities and movement. That affected the ability of legal practices to operate, because we were all restricted to our homes. There was a lot of debate about whether legal practices were essential services and whether they could operate. During that period, there was confusion regarding who would issue the permits, whether this was done by the Legal Practice Council or the law firms themselves. It was done by the Legal Practice Council, but there was uncertainty as to whether it was the Legal Practice Council nationally or provincial offices. Some types of area of practice that it means that some functions in the law firms were worse affected than others, in the same way that some types of work were not as drastically affected as others. There's some types of work that people would almost transition seamlessly and do on a remote basis, whereas other areas, lawyers really struggled. Also, that because the changes were so drastic and sudden, we did not have time to plan and to implement measures. We all had to change to the conditions that existed under the national state disaster, and then had to try and figure out how we operate without any precedent for this. And then the result was that operations in legal practices were affected. Mandates could not be completed, whether completed timelessly or at all, and the ability of firms to earn an income was really drastically impacted. The inability to operate to the full extent for many practices was one of the large risks which emerged. You'll recall that the courts and a number of quasi-judicial offices were closed for a period, and in other instances they only provided very limited services. And even after the lockdown measures were eased and some activity or more activity was allowed, we then had the periodic closures, because whether it be the master's office, deeds registry's office, and even the courts had to close from time to time due to positive coronavirus cases. Sheriffs are an important cog in the wheel, and they only provided limited services. They said that they would serve urgent processes. We got the reports that some sheriffs were being stopped by the law enforcement officers when they were on their way to their offices. All that really affected lawyers in the work that they do. And you will also recall that for a time, certain services that are carried out by the sheriffs, such as evictions, could not take place. In this, law firms that deal with in debt collection and that type of work were also affected, as were their clients. The challenges in serving documents increased the risk of prescription. There was some uncertainty for whether prescription continued to run during that period, and many firms in South Africa pursue RAF work. The RAF offices were closed for part of the lockdown. The total closure of those offices meant that claims could not be lodged. Claims that were already lodged could not be processed. There were risks, once again, of the prescription in respect of those matters. So the lockdown measures really had a significant impact on legal practice. Not all firms were geared to operate in the changed circumstances. Many firms, for example, still used paper-based files, paper-based systems. They were not geared to operate in an environment where there was an increased reliance on technology. As I've stated, because the changes were so sudden, the risk caught many people unprepared. Some resorted to the remote working, but this had its own risks. Supervision of staff could not take place properly. The people had not drafted policies and systems to allow for adequate supervision and oversight when certain members of staff were operating remotely. Training programs for candidate legal practitioners were affected because now firms couldn't do their internal training, and there were many people who were unfamiliar with the use of technology. A lot of us these days use the platforms such as Zoom or Microsoft Teams seamlessly, but that wasn't always the case. There were a lot of hiccups at the beginning, and the technology itself brought its own risks, because as we move to this online way of operating, for example, we also had the cyber threats. We saw an increase in cyber threats. Some legal practice had to abruptly close or downscale. And when I say abruptly close, they could not follow the proper procedure for closing. Others downscaled. Some legal practices that have just not been able to take off again after the closure. A number of questions arise because the coronavirus pandemic is by no means over, and you also need to consider the risks in case we are faced with a similar situation in future. So when you do your risk assessment, consider how your firm will operate in the wake of the pandemic, the new risks that are brought about by the use of technology. And on the human side, in the event of prolonged illness or death, unfortunately, how will your firm be effective, and what measures do you have in place to ensure its sustainability? If a significant fee earner suffers from illness as a result of the pandemic, or if there's death of a significant fee earner, what will the effect on the practice be? Have you considered, when you look at that risk, purchasing products such as key person policies? These are what in the insurance market are commonly referred to as key man policies. This is it's a policy that will kick in and pay out to the firm as the beneficiary in the event that any of the people I've mentioned either falls ill or is disabled or unfortunately dies, to ensure that the firm continues operating. And you also need to consider a business interruption policy. If you have such a policy, you need to look at whether the policy will cover risks flowing from the pandemic. After the first claims were notified in 2020, the first claims notified to the insurers or in terms of the business interruption policies, many insurers changed their policy wording to exclude risks related to the pandemic, and also others tightened their wording to say that it will only be a physical loss. there were debates about what triggered the inability to operate in the business interruption, whether it was the pandemic or the lockdown measures. And there were other debates about the policy wording which are not relevant for current purposes. You can look at those resources I have listed there if let's cover the COVID-19 is particular. The cases I've listed on this slide are cases brought by insured entities against their insurers in order to trigger cover under the business interruption policies. In order to recover losses they suffered as a result of the pandemic and the lockdown measures, the inability to operate. The broader economic environment, yes, the economy was severely affected by COVID-19, and distressed economic circumstances mean that clients have less money to spend on legal services, and that clients will choose carefully what legal matters they pursue. The income of law firms greatly declined. Lower interest rates and the interruptions to the operations of law firms affected even the income of the Fidelity Fund. You will recall that the Fidelity Fund is funded by the interest earned on trust accounts. And the level of interest is a factor of the interest rates and how much money law firms have in their trust accounts. And when law firms were not able to operate, that affected the income of the fund. The distressed economic conditions may, for some who are that way inclined, increase the temptation to misappropriate client funds. Please do not do that. Distressed economic circumstances are no justification to break the law, to breach your ethical duties, and to steal the funds that belong to someone else. The impact of the virus on professional indemnity claims will also only become known in time once we have sufficient data to analyze the trends. But I've mentioned in session 1 that times of economic distress usually coincide with an increase in professional indemnity claims against legal practitioners. Clients with their own restrictions and challenges will expect more for less. They'll be more circumspect in the type of legal matters they pursue and also which firms they engage. On the other hand, law firms will be hard pressed to pursue mandates, but with less resources, because some of the key staff may have left the firm, but the remaining people will feel a need to survive and therefore try and do more. This results in people being thinly stretched, and that's a real risk for errors to occur. There have also been multiple threats to the sustainability of many legal practices. For example, the changes to the RAF model affected both plaintiffs and defendants' attorneys. The defendants' attorneys who were on the RAF panel suffered a situation where the RAF sought to terminate its panel and bring the litigation in-house. There was a number of transfers of litigation in that respect, and unfortunately the former panel attorneys were not successful. when I look at the various papers filed in that litigation, I count 102 firms that are affected. 102 firms means that there are a lot of, that amounts to many people affected, and also that is a significant percentage of the legal profession in South Africa. For many firms, the RAF was the major client, and in some instances the only client that they acted for. Attorneys acting for plaintiffs against the RAF were also affected, as I've already mentioned, by the closures of the RAF offices. The RAF also changed its conditions under which it will accept claims. A management directive was issued. It changed its schedule for making payments, and attorneys practicing in this area mainly act on a contingency basis. So they act on a risk basis. They have invested time and money in the pursuit of the claims. There are medical, legal, and other experts that have been engaged. And when those experts don't get paid, they look to the firm for payment, and in some instances have instituted action against the firms for payment. And all these circumstances really affect a big part of the legal profession in South Africa. The point here is that you need to consider how the economic environment affects your pursuit of your strategy, and you need to take it into account in developing the risk management plan. What happened with the RAF is just one example of what can happen to you if you lose a major client. So what risk mitigation measures do you have to put in place in case you lose a major client? Is there a huge concentration of your income and your resources aimed at serving one client or a few clients? So please consider that as well. Other questions you need to ask yourself following on what has happened in the economic environment is, have you lost any key staff, and what has been the effect of the loss of the key staff? The current conditions also create opportunities for certain people. So some key staff may decide that they want to branch off on their own, or they want to join other practices. Some of the practices you are competing against may have opportunities and decide to poach your key staff. Is your firm still sustainable? And if it is, for how long can it survive if the current circumstances persist? What measures do you have in place? What changes have you implemented? And what reserves do you have to have in place to assist you to weather this storm? Business interruption. This business interruption is if I could put it simply, is an event or occurrence that interrupts your ability to operate. This could be, if I could take an extreme example, your office burning down. What would you do if your office burns down? And maybe that's not such an extreme example. A few years ago, I wrote in the Deregos about a practitioner in Johannesburg who suffered that unfortunate fate. He was working in a building, a high-rise building, and a few floors below his office, there was a fire, and it happened, the fire broke out in the evening after many people had left the office, and he was, in fact, left alone in his own office because the staff had already knocked off and gone home. He did not realize what was happening below him, and when he did eventually felt that there was something going on, he then couldn't get out of the building because of the fire in the floors below him, and was overcome by smoke inhalation, which led to which rendered him unconscious. He was hospitalized for a few months, and when he regained consciousness and had recovered to the extent that he could start checking what was happening in his practice, what he has indicated to me is that he got back and realized that there was no practice left. First of all his files had burnt. There's nothing left, and the computers as well. The staff who had tried to hang around for a few weeks because of the uncertainty of him being in a coma were really concerned that he may not make it, and they went off to join other firms. Others contacted clients and took clients with them. Clients has also had the same uncertainties. One of the questions that arose, and it's not a matter of being wise after the fact, is the importance of one, having insurance cover over your office contents, so that the cover can kick in the unfortunate event similar to those of that practitioner of the fire, and also once again the importance of considering having an electronic system for filing. But all these really talk to having a business continuity plan and a data recovery plan. The business continuity plan is a plan that will kick in when you have a business interruption to ensure that the firm can continue operating. As lawyers, we are heavily reliant on data, so your data needs to make your business continuity plan needs to include a data recovery plan. When you are unable to complete the mandates because of a business interruption, that affects the time periods within which you need to do that, because the clock is still running, as well as the quality of the output, and it also affects your income. Having a business continuity plan and a data recovery plan hopefully will ensure that you can get up and running as quickly as possible. Your staff need to be trained on the business continuity plan and the data recovery plan, and it needs to be updated often, because every time there's a change in circumstances, please change it as well. And a big part of your business continuity plan is communication, so that you can inform clients of the change. So if you move it into new premises, clients and other stakeholders can be informed. Load shedding and interruption to municipal services are also common interruptions. I have mentioned that in the last year, I've seen load shedding being referred to more and more in the court papers. This is in the context of applications for condonation of a failure to meet timelines, where practitioners state things such as the work could not be completed in time due to interruptions caused by the load shedding, that documents that had been drafted were lost because servers crashed because of the load shedding, And firms are sitting with staff who, for long periods, cannot work because of load shedding. So please consider alternate power supplies and alternate methods like UPS systems that can help you to operate when the power goes. And also, you need to investigate alternate premises from which you can operate. This is whether you have a big business interruption and you cannot use your premises for a long time, or even during load shedding. There are a number of landlords who, as part of the leases that they offer clients these days, also have an option for alternate premises from which you can operate in case the main premises are unavailable. There are also companies who, for a relatively small fee, offer you premises that you can use. Those companies are specialists in this area and will also provide you with the technological backings to ensure that when you move to their premises on a temporary basis, you'll be able to access your servers and any electronic data you have. But when you're looking at premises, please ensure that you don't take premises that are on the same electricity or water or ICT grid as your main office, because they will then be offered at the same time as your office. And your business interruption premises, your business continuity, the premises that will be used for your business continuity plan, do not need to accommodate your entire office. What you can do is identify the core functions and the core staff that you need to enable your firm to continue operating, and then those people can be accommodated in your in the premises that you've identified. You can purchase a business interruption insurance policy to assist you in this regard. And in purchasing the business interruption policy, please ensure that through your broker, you ascertain whether the policy will cover the cost associated with the procurement of alternate business premises. Many policies do so. They will kick in and pay your rental at your alternate business premises from the date that your main premises are not available. Check that it will cover you for the loss of profits and the increased cost of doing business, because the move to the new premises may cost you more. Check whether it will only cover losses flowing from the physical destruction of the premises. That is a consideration that's important when you want to look at losses flowing from the current pandemic or future pandemics. And also there's a debate regarding whether load shedding is a physical act. An experienced broker will be able to guide you on that and to get the appropriate cover. Cybercrime. As I mentioned in the first session, cybercrime has been on the increase in South Africa for more than a decade now, and legal practitioners haven't been spared, been targeted by that. Internationally, there's been an increase in cyber attacks against legal practitioners during this time of the pandemic, and this is for a number of reasons, including one, that when we had to transition to the remote and hybrid methods of working, we did not have time to draft proper internal processes and discuss how the matters would be dealt with. So checks and balances were relaxed or even abandoned in some instances. This applies to both to law firms themselves as well as to the clients also went through the same thing. There was also a lack of supervision in this new way of working because we was used to supervising staff who were actually in the office. The IT security measures that staff have at home may not be on the same level as at the office. At the office, you could have invested in an advanced IT system and have the benefit of experts who come and test your vulnerabilities to ensure that your firewall is in place and that it is effective, that there are systems to block malware and viruses. And people working at home may not have had that. There's what cyber criminals around the world also increase their efforts. We, for example, at the office have seen that our firewall is very active, blocking more and more phishing and spam emails. Some of them, unfortunately, do get through, but you need to delete them without opening them. Getting lots of SMSs that are purportedly from the bank saying that accounts will be closed if we don't log on and update them immediately. And there's a link that comes with the SMS. Delete those also without opening. Do not open those links and block the numbers from which those SMSs come and the email addresses if they sent by email. And there was also a decline during the pandemic of alertness. Maybe this was partly due to the shock of the changed working circumstances, and maybe after a while it became a matter of pandemic fatigue. But the thinking is that people working at home were also more relaxed and thus dropped their guards. And then we also have had instances where payments need to be made in a hurry. So people rush to get the payment out, but do not check if everything is in order. Remember what we said when we spoke about segregation of duties and people that stand over you to make an urgent payment. Rather, take time to check that everything is correct before you make those payments. So the main types of cybercrime, ransomware attacks. Ransomware attack is an attack where cyber criminals invade your office, do have a virtual invasion of your office. They take charge of all the data and all your operations, and then send you a message telling you that they are now occupying your office and that you will need to pay them. And the payments need to be made in a cryptocurrency, failing which they'll sell your data and your information of your clients to the people in the dark web. If you have cyber insurance in place, and please consider purchasing cyber insurance. Your cyber insurance policy will have a process to assist you with a ransomware attack, because you'll need the advice of cyber experts. There needs to be a communication plan in place to communicate with clients. If the decision is to pay the ransom, then your cyber insurance policy will pay the ransom. There may be criminal or regulatory actions after that. Your insurers will get experts on board to assist you with that. Phishing is something that's very common. This is whether it's by emails or SMSs or other communication, where people just want to get your information, particularly passwords and the like, so that they can access your documents and your bank accounts. and steal from you. Hacking, someone breaking into your cyber and environment and sitting there unlawfully and writing as if they were you to other parties and doing all sorts of illegal acts. If you want a well-publicized cyber attack, was that on the Panama the law firm Mossack Fonseca a few years ago. You can read it's well documented what happened there, what its effects were, and what the status of that firm is today. Business email compromise. This is the most common form of cyber attack on South African law firms, and it involves a fraudulent change of banking details of the intended recipient. I'll show you take you through a case study that shows the most common way they do it. But remember that cyber criminals attack both the payments made by law firms. So, said it before, cyber criminals do not discriminate. They want your trust money, they want your business money, and they want your data. So they steal money whether it's yours or whether it belongs to clients. They steal money that you are intended to pay out, as well as payments that should have been made to you. So when you needed to pay a client, they would send you an email pretending to be the client and give you new banking details. If you needed to pay an estate agent or pay another law firm, they'll do the same. But in the same way, they'll send communication to your clients or to anybody else who's due to pay you and give fraudulent banking details. What is really concerning is that we still see law firms that send even accounts that are in Microsoft Word format, not even PDF format. That is even making it simpler for clients to change banking details, and money that should have come to you will end up in their pockets. So what is the common modus operandi out of these business email compromise scams? I trust that you'll remember this when you deal with the cybercrime question in the assignment. So I'll read it. A is selling her property and instructs BCD Incorporated attorneys to attend to the transfer. BCD Incorporated attorneys accept the instruction and, as part of the process of onboarding the new client A, obtain her banking details. Her account number is 1234, held with Big Bank. As the transaction progresses, BCD Incorporated communicate regularly with A on her email address, aclient@gmail.com. The transaction is finalized and BCD Incorporated attorneys need to pay the proceeds of the sale to A. A few days before the payment is effected, BCD Incorporated receive an email from email address aclient@gmail.com purporting to be from A. The email refers to the matter being attended to and instructs BCD Incorporated to pay the proceeds of the sale into account number 98766 held with Huge Bank. The email states that A intends closing her account at Big Bank. The email also gives a phone number different to the one the firm has on record for the staff at BCD Incorporated to contact the sender in case they have any queries. The team at BCD Incorporated act on the email instruction and make the payment into the account at Huge Bank in accordance with the instructions in that email and send the proof of payment to that address. A few days later, A contacts the firm wanting to know where the funds due to her are. The firm sends her the proof of payment, but she says that she has not received the funds and that she did not send the email. A instructs another firm to litigate against BCD Incorporated to recover her money. And so BCD Incorporated problems start. I hope that by looking at the slide or the modus operandi, if you haven't noticed, nothing that's popped out of to you regarding the email addresses, then I think that you are in trouble. So 3 questions I'd like you to consider. Firstly, do you think that BCD Incorporated is liable to A for the amount claimed? Secondly, did the firm do anything wrong in acting on the email, on the instructions in the email? Sorry. And thirdly, if the firm is liable, what steps can it take to mitigate a similar loss in future? Had we been doing this on a face-to-face basis, we would have interesting discussions regarding these 3 questions. But sorry about that. My view on the matter is that the firm will be liable to compensate A for her loss, and that A will either bring a claim based on the breach of mandate, that's a claim framed in contract, breach of a duty of care that the firm had to her. A claim would then be framed in dealing, or she can argue that the firm had a fiduciary duty to her, because they were sitting with money in the trusted account. And the answer to my view is that yes, that should be they did do something wrong and thus have to compensate her. My authority for this, please read these 4 cases. Foree versus Van der Spey and de Jong Incorporated, Jurgens and another versus Phishing, and Galactic Auto Pty Limited versus Venter, and Lochner versus Schaefer Incorporated and others. See Foree versus Van der Spey and de Jong and others, and Jurgens and another versus Phishing, some of the steps that the respective judges took suggested in that matter should have been taken by the firms involved to verify the instruction to make the payment in line with what we had written previously in the risk alert bulletin. What steps could they have taken and to avoid similar losses in future? So what the first thing that you do that you need to do is to read about this risk, empower yourself with the knowledge so that you know the extent of the risk, how it's commonly carried out. Also know your obligations in terms of the Legal Practice Act and the rules, and have documented processes in place to verify all payment instructions before making the payment. So the verification must happen before you make the payment. Other suggestions that you can consider are to obtain the client's banking details and the original bank stamp documents from the client when you take the initial instruction. Warning, do not accept emailed bank stamped documents, because the cyber criminals create letters from what looks like a letter from the bank on a bank letter confirming the banking details. They create bank statements, and all these documents have what looks like a bank stamp, and it will have a recent date on it. So don't accept that, rather take the originals. Insist on a face-to-face consultation and with clients and incorporate this into your FICA verification process. Inform the client and all other parties that no changes to banking details, including yours, will be made by email, and add this condition to your letter of engagement. Clients complain that this is rather tedious. Explain to them that this is to protect you in as much as it is there to protect them. And also give them copies of the risk alert bulletins, which you can download from the website, showing them the extent of this, as well as the materials in their use. And explain to client that this is one of the suggestions from your professional indemnity insurers. Use the account verification systems offered by the banks and other financial institutions. Some of these institutions charge between 100 and 150 Rand per transaction in order to verify banking details. It's really a little bit of money, taking into account the value of the losses you suffer. Another very simple way of doing it is, if you have somebody's account details, go to an ATM, take it out note, in a small note, like a 20 Rand note or a 50 Rand note, put it into the ATM, enter those account details, and go through the process as you would if you were legitimately depositing the money. Before you complete the instructions, it will show you the name of the account holder. Then you can cancel the transaction and take your note out. So also insist that the recipient of the office attends the office. The recipient of the funds attends your office in person when any changes to banking details have to be made legitimately, because there may be circumstances where the client legitimately needs to change banking details. But once again, ask them to come into the office in person. Contact the client on the telephone number on record, not on the email that you receive, to inform him or her of the email reporting to be a change in banking details. Remember what was stated in our case study that we've just done. And this will also help the client in case there's some breach in the client's environment, the IT environment. So they'll be alerted. Place a prominent note on all correspondence that your firm's banking details haven't changed. Alert readers to the scam and state that no change in banking details will be made by email. I see that many firms are now putting this in their email signature, which is a very good approach. The alert if the purported changing details are made just before the payment is due to be made. What this just means is that somehow the cyber criminals have gotten into breached the security measures, either gotten into your firm's environment or into the environment of the party who's receiving the payment, and that's how they can see the correspondence and know at what stage the transaction is. Because the only time they'll communicate with you is when the payment is about to be made, and they'll communicate with you about the payment. All other details of the transaction and all other events that then steps in the transaction they are disinterested in. Have a documented internal procedure and ensure that staff comply with it to verify banking details and any purported change in the banking details. Verification is prescribed by Rule 54.13.54.13. Educate clients and staff on cyber risks. You can also start by giving them the resources referred to in this presentation. Get a cyber expert to come into your firm to conduct a risk gap analysis, to look at the effectiveness of your firewall, your security settings. They can give you a report on your vulnerability. and areas that you need to improve, and they do what they call penetration tests to see how easy and how far the cyber criminals can get into your system. Cyber risks must be included in the assessment that you do to comply with Rule 54.14.7, Rule 54.14.7, Rule 54.30 refer to the trusted account, the trust accounting environment, but the same principles should be applied to all funds and all data. So business, investments, estate-led accounts, any money, because criminals will want to get their hands on. Educate your staff and clients on the risks of clicking on links in documents from external parties, or opening attachments on emails from unknown parties, because that's where the malware is, and those are the documents they use in order to carry out their phishing exercise. And I have to break it to you, you did not win the lottery in a competition where you didn't even buy a ticket. So the email you received or the SMS about you having won the lottery is false, fraudulent. In the same way that the correspondence you receive that some unknown person is either about to die or has died and has left you millions in inheritance, that is also not true. There's a criminals trying to get to dupe you into giving them your banking details so they can steal your money. When you receive an unknown invoice or correspondence purporting to be from SARS correspondence will usually say something like you've got a fine to pay. So there are a lot of tender documents that are floating around, particularly now until in 2010, 2022, and these are, I use the words tender documents in inverted commas because they purport to be from state-owned entities. They want you to bid. Please do not open them, delete them. No entity is going to write just directly to you, but they send you a tender document. That on its own should raise your suspicions. Or documents that are headed new urgent instruction and or offer to purchase, or anything of the like that just come from unknown parties. Do not accept them. And I know that none of the current company will fall for this, but just please tell the people in your firm in any way. Tell them to stay away from pornographic websites, gambling websites, websites that where you can download bootleg music, so to movies and the like, because they are very high risk for malware. Those are the for malware and viruses. Those are the sites where, if the party to opens them soon gets the message that says that there's a virus on the device, and they must click on a link in order to clear the device of the virus. Those are cyber criminals that want to get into your device. Don't use public Wi-Fi sites. You do not know what is on there in terms of viruses and malware, and you also don't know who is on there. So you may think that you are just using it to check your emails, but somebody else is also downloading them then and checking them. Look at the LPWF and LSSA websites for more cyber related information. Please read Rule 54.13. Says that prior to making any payment, that the firm must take adequate steps to verify the bank account details provided to it for the payments, and that it also says that any subsequent changes to the bank account details must be similarly verified. Internal controls, Rule 54.14.7 prescribes these. You can read it, it's also quoted in the manual. In the event that you fall victim to a scam or any other theft resulting in a deficit of your trust account, the shortfall must be reported to the Legal Practice Council. Please see those rules that are quoted there. Remember them for both your assignment as well as when we deal with theft. That many people forget this step, that the shortfall must be reported to the LPC. And cyber criminals hack into your environment. They have access to the personal information of your clients and any other person whose details you have. So there may be POPIA implications, as well as implications in terms of the Cyber Crimes Act. So also consider that. There's also regulatory matters to bear in mind. And then the principle Rule 12 of King 4 states that the governing body should govern information and technology in a way that supports the organization, being ethical and a good corporate citizen. So the governing body is you as the partner in the firm. For cyber risks, buy a cyber risk insurance policy, or what other people call a cyber crime policy. Purchase it in the open market, the open commercial market. So remember this for yourself as well as for the assignment. Cyber-related matters are excluded from the LPAA policy. Read clauses Roman numeral 9, 60 and 16.0 of the master policy. As I've said, this risk can be insured in the commercial market. Many people say that cybercrime cover is expensive. The prices should certainly have increased in recent years, but as with everything, the risk will be priced, and the terms of cover that will be offered are based on the risk of your firm. A big part of what the insurers will look at is what internal measures do you have in place to manage cyber risk. If you were to follow those measures that suggested, that will help you bring to negotiate better terms of cover. So many insurers now offer cybercrime cover as a standalone policy. That means that it's a policy that only covers this type of crime. Up until about a year ago, there were professional indemnity policies that offered a limited amount of cyber risk cover, and in some instances, those policies, the policy wording stated that there had to be hacking in order for your cybercrime policy to be triggered. So, which meant that if you suffered from a business email compromise claim, and you couldn't prove that there was hacking of your firm, then the policy wouldn't pay. If the claim against you is framed on the basis that you are a director of the firm and you are sued in that capacity, that you failed to carry out your duties as director, check with your broker whether the directors and officers liability policy, which is commonly referred to as the D&O policy, will indemnify you. In addition to all these policies that I've mentioned, ask your broker about the commercial crime insurance cover that. It will assist you for the losses. And your other policies, business interruption and public liabilities, some of them offer a small amount of cybercrime cover. So, seen public liability policies that's pre-2019, which, for example, say that they would cover your, in respect of your devices that would give you 20,000 rands that cover, but that is something, but it's very minuscule when you see the value of the losses you have as a result of cybercrime. There are the resources that will assist you in looking at this risk. Cybercrime has been covered in many articles in the practice management column there. Going on to our next risk, prescription. And what I state here is related to prescription. You'll remember from our claim numbers that prescription is one of the highest risks. It's one of the areas from which we do receive the most claims. But the principles can also be applied to any type of matter where you are facing a statutory time limit. But so you can adapt what I say accordingly to those. But we'll focus on prescription because of the risk it is. Before you even accept an instruction, ask yourself whether you have the appetite, the resources, the expertise, and the time to pursue the instruction. If you don't, do not accept it. Has the client provided you timelessly with all the information and documents necessary to pursue the matter timelessly? If not, it may require that you keep chasing the client, and when the client doesn't comply with your requests, the clock will be ticking and prescription will be drawn closer. Another important consideration, which I want you to please note, is that you should never take instructions that when it's close to the prescription date. You need to register all your time-barred matters on the LPW's prescription alert service and to adhere to the reminders sent out by that unit. Prescription alert service, this is a computerized diary system that the LPWF offers at no charge to members of the profession. You go onto the prescription alert website page. The prescription alert page is on the LPWF website. You first register your firm, and thereafter you start registering every individual matter you have. The unit will send you reminders as the prescription date draws closer. And please act on those the reminders. Taking full and detailed instructions at an early stage of the matter is also really important. That also is related to client providing with all information and documents. Do not procrastinate. Act promptly. Please have a look at the judgment referred to in your notes of Mlenzana versus Goodrick and Franklin to understand how procrastination can cause enormous problems for you. Supervise staff. Ensure that matters are attended to timelessly. Do not just accept their word. Make notes to follow the issues up. If necessary, take over the matters, deal with them yourself, because this is a risk which you will be ultimately faced with. Conducting regular file audits and a system of peer review will also assist you. If you can't attend to a matter, have a consultation with client. Keep detailed file notes of the consultation. Send the client correspondence confirming that. If it means that you would sending them off to another practitioner. Tell them prescription is looming, point it out in the correspondence because it will save you. Educate staff on the prescription period. Be alert to the statutory notice periods for claims against the state, against state institutions. Study the law so that you know when prescription begins to run, when it's suspended, or when it is interrupted. Please have a look at the Constitutional Court judgment in the matter of fund sale NO versus the RAF. That judgment was handed down in November 2021. Please also look at judgment handed down on the 21st of June 2021 by the Pretoria High Court, matter of the LPIF versus the RAF and the Minister of Transport. In the LPIF matter, we challenged the 2-year prescription period for hit and run claims against the RAF. The fund sale matter dealt with when prescription begins to run for the persons who are under curatorship due to head injuries, and the court confirmed that those prescription only starts running when the curator is appointed. If you need help with the law relating to prescription, please contact us. We'll provide that to your firm free of charge. We also have numerous resources available on our website. It's cheaper for us to assist you in the law in that regard to challenge prescription than it is for us to pay a claim. Regular review of files and closing them out, advising clients we've covered, implementing a peer review system we've covered. Do not assume that prescription is 3 years in all cases. Designing and implementing a dual diary system with your secretary, candidate, attorney, or paralegal will also assist you, because in at least it will help that nothing falls through the cracks. Ensure that the correct course of action is treated and that the action is instituted in the correct court. Your opponents may realize that that there's a problem, but they won't say anything until later in the matter, after the prescription period has passed, to point out to you that you've actually pleaded an incorrect course of action, and then it's too late to withdraw and start afresh because the claim is prescribed. It's the same as actions instituted in the incorrect court. Incorrect court, incorrect division or magisterial district, or division of the High Court or the magisterial district. And also we have had numerous cases where action is instituted in the regional court because the attorneys concerned have not considered the quantum. By the time they realize that quantum exceeds the jurisdiction of the regional court, and that they should have been in the High Court, it's too late. Your opponent will snatch at the bargain and not agree to a transfer. You'll be put in a corner where you either undersettle the matter, or because you settle it for the maximum jurisdiction of the regional court, and when the client will then sue you for the difference. Be wary of the tactics of your opponents. If you are involved in negotiations and the claim is coming close to prescription, and the opponent says to you, don't worry about it, it's about serving summons, would have finalized it by the prescription date. Say to them that you would rather serve summons on them just to interrupt prescription, and the negotiations can go on in the meantime. If you agree that the running of prescription is suspended, record it clearly in writing. Also remember, this is a mistake that many legal practitioners make. It's the service of summons that interrupts prescription. Please have a look at section 15, subsection 1 of the Prescription Act. If you fail to register a RAF matter on the prescription alert service and to comply with the reminders, the LPWF will levy a higher deductible, that is a higher excess. I'll address that when we talk about the policy. Under settlements. Under settlements, these are claims brought against legal practitioners where they pursued a matter usually for the plaintiff. The matter has been settled and they receive the amount of the settlement. The client then says, but the amount you settled it for is less than the damages that are suffered and was entitled to, and the attorney is then sued. So in a lot of these matters, the attorney has just relied on the widely worded power of the attorney that gives them authority to do all sorts of things, including settle the matter. Do not rely on that. Properly quantify the matter and ensure that you get the best possible result for the client. With every offer that you receive from the other side, you have an obligation to put it to your client. The authority for that is Goldschmidt and another versus Fob and another, which you will also find in your manual. Consult with the clients on the implications of the settlement and record the consultation in writing. Whether it's your recommendation to accept or reject the offer. Another huge risk when it comes to under settlements is a failure to keep clients updated on the matter. Ensure that you write to client and to inform them on what is happening in the matter at all times, to keep them updated so that they are always abreast of developments. Remember the once and for all rule, and to explain it to clients so that they don't think that the payment that's been made to them in terms of the settlement is part payment and they'll be receiving further monies. Future, be wary of clients with unrealistic expectations. Manage the expectations earlier. Ensure that you've properly assessed your quantum and obtained medical, legal, and actuarial calculations. Run the offer by your experts as well. Be careful of pressures from your client's family to just want to settle the matter and just want the funds. If you are acting for a minor or a person where a curator should have been appointed, have the curator appointed to protect the underlying client and yourself. If the event that is no underlying client and you're acting for the person whose claim it is the one that's pressurizing you to settle, and they want to go against your wishes, put that in writing. We've noted there's one firm in Limpopo that does this very well, that they get their clients to depose to affidavits. The affidavits are even deposed to Inchivenda, where the client is setting out that I'm going against my attorney's wishes and I'm accepting the offer. Obviously, that affidavit is not sent to the opponent. The attorney keeps that for himself in his file, and he often reports matters to us just as a courtesy, as a cautionary measure. Not that there are claims against him, but I think that is a brilliant idea. Leave the door open for the client to obtain a second opinion if they require one. Beware of settlements at roll call or the doors of of court, on the day that the trial is due to commence, there's toing and froing and negotiations between clients, and where you and your opponent are say to each other, okay, you at this figure, I'm at that figure. Why don't we just split the difference and settle for half? Be careful of those. Phone the client and inform the client. If they have decided that you've taken into account the risks involved in litigation and the time it will take for the matter to be finalized, discuss that with client. If this is happening at court, if there's a physical hearing, phone the client. A lot of us use smartphones these days that have got recording facilities. Record that on your phone so that you can have it, and then later when you get to the office, you write to clients. So commercial settlements and as I mentioned, what we call risk settlements, those are risky. Please read that article in the November 2018 Risk Alert Bulletin to help you understand many of the risks that we have covered. So we come to theft. So theft is a crime. It's also a breach of the ethical duties of a legal practitioner. The results are that the guilty parties will face three-pronged activity. One, the Legal Practice Council will take disciplinary action against the defaulting party. Secondly, the criminal proceedings will be instituted against the defaulter. And thirdly, the client will institute action against the defaulting attorney. Remember that when you say attorney, once again, I'm referring to attorney or trust account, the advocate. So remember that what will happen is that in the event of a theft, the client will need to exhaust all the legal remedies against the party involved. We call them the defaulter, and before they can proceed against the Fidelity Fund. And that's why they just say that the client will need to excuse the defaulter before they can proceed against the defaulter. Please study the Legal Practice Act and the rules so that you can understand what your obligations are, what they prescribe for you to have in place, and know what your obligations are in respect of financial controls for your trust account, for the investments, and for the estate later accounts that you are dealing with. Know your ethical duties. Teach all those three blocks to your staff as well, so everybody knows. If your practice is not financially viable, consider other options, whether it's to sell your practice, to merge with another firm, or to leave practice altogether. Never put yourself in a situation where you struggle to be at a point where you'll be tempted to dip your hands into the cookie jar. We've spoken at length about the need to develop to have a system of segregation of duties in place. Please remember what was said there. Another important principle that you need to consider is that please do not keep monies in trust for longer than it's absolutely necessary for you to do so. So when an instruction is completed and you've done all the accounting and the recons, please pay those monies out. The longer they sit in a trust account, the longer the risk is. When you look at claims against the Fidelity Fund, that ultimately end up at the Fidelity Fund, and you look at when the theft happens, and the theft usually happens when money's been lying in the trust account for a long time, then people get tempted to steal it. Or if you are acting for a client who has money sitting in the trust account of another legal practitioner, and the other party keeps giving you stories and giving you the runaround why they're not paying it out, that should be a red flag. Report the matter to the Legal Practice Council immediately and start instituting action to recover those funds, because you may find that the reason they're giving you and your client the runaround is that they have started dipping their fingers into that money. Do not accept the word of people internally as well. That old principle: to trust is good, but not to trust is very good. We see an increasing number of claims where legal practitioners are shocked that when they realize that there are shortfalls in their trust accounts, and that the shortfalls have arisen after they've believed what the trusted bookkeeper has said for months. So, and these are legal practitioners in many instances who've handed over the control of their accounts to the bookkeepers. Please be careful of that. The buck will ultimately stop with you. And I've said to previously, don't accept documents and explanations on face value. Have a level of professional skepticism. Tell your staff that this is to protect yourself and them. Also, please remember what we said when we dealt with the cybercrime. Your obligations to report shortfalls to the Legal Practice Council. Remember that principle again, and what is stated here, as well as in your notes when you deal with the theft question in your assignment. You can purchase misappropriation of trust fund insurance, so misappropriation of trust money insurance, as some people call it, in the commercial market. If you have that policy, once you become aware of the shortfall, report it to your insurers as well. So the misappropriation of trust fund policy, or misappropriation of trust money policy, as others call it, that will cover losses of trust monies, but it will not cover losses in your business account. Losses in your business account are covered by a policy, and please do not be confused by the wording. It's called a fidelity guarantee policy or a theft of own funds policy. So that is the policy that will cover losses on the business side. I've said to you need to remember your obligation to inform the regulator in the event of a trust shortfall. Also remember Rule 54.14.7 that prescribes the internal controls that you need to have over your trust monies. Theft claims are excluded by the LPII policy. Remember that for your assignment. Have a look at clauses 16B, 16C, 16T, and 18 of the LPII master policy. in the risk alert bulletin and in the practice management column of the Rebus, you'll get a lot of resources relating to theft and measures that you can implement. Please read those, and they will assist you in your own practice, and those resources will also assist you when it comes to the assignment. Thank you very much. This is the end of session 4. I will see you in session 5.